So this will constitute the minutes of the Zoning Board of Appeals, Tuesday, September 22nd, 2020. It's 7:30 p.m. Sitting as the Board of Appeals are Woody Chittick, Dave McMorris, Lee Darst, Matt Watkins, Charlie Higginson, and Peter Gertica are not yet present, but are expected any moment, but we do have a quorum. And Jen, I'm going to turn it over to you, Jen, for a couple of minutes, or a minute or so, just to explain the process and procedure here, okay?
Okay, sure. Thank you, Mr. Chairman. So we have 3 appeal hearings this evening. The chairman will open each hearing, and then what we will do is promote those who are attending this meeting as far as presenters and landowners. And then if that group wants me to promote other people, they can request so of the chairman, and I will do it. As we're starting, I will also give everybody screen sharing abilities, and then with the permission of the chairman, you can show plans, etc. So the first appeal is the one with Brenner Maxwell Esquire. And so, Woody, if you want to read the opening of that, I'll promote the members I know that are present that wanted to speak, and that would be the attorney, John Cavanero, would be attorney Jason Curtin. We have John Cavanero and Mr. Wyndham, the landowner. So I'm going to do that right now.
Okay, so this is an appeal by Jonathan and Tracy Wyndham of 482 Jerusalem Road, an appeal of the building inspector's issuance of a building permit for the raising and reconstruction of the house at 488 Jerusalem Road. We have a subsequent appeal not quite a month later by them for the building inspector's letter basically refusing to enforce a cease and desist and a reapplication. So if the applicants, I presume, are probably represented by Attorney Curtin, but whomever would like to speak. And what we'll do, just for everybody's edification, well, for those sitting in particularly, we'll open the hearing, hear from the appellants, hear and any expert they wish to bring forward. We'll hear the other side, and then we'll open it up after the board has had a chance to go back and forth with either of these two sides. We'll then open it up for public comment, but not until then.
Right, and we will use the public comment. We will request if people could do the Q&A, and we will read those questions and hopefully be able to answer those live.
Okay, I see that Peter Gertica has joined us. You're muted, Peter, but that's okay, but you're there. You're muted. If you can hear me, you're muted. Your mouth is moving. Okay, well, at any rate, we'll proceed ahead. So who is going to be the first person to speak on behalf of the Wyndhams?
I believe it's going to be Attorney Curtin and John Cavanero.
Okay. Who's going to go first?
I'm going first. My name is Jason Curtin. I'm just trying to activate my video. I see that it's not start video. Here we are.
There you go.
How are you this evening? I just want to first thank the board for holding this special hearing. We very much appreciate the board making this time available, particularly because construction at 488 Jerusalem Road has rapidly accelerated since the Wyndhams filed their appeals. As you are aware, the Wyndhams have filed 2 separate appeals. One appeal relates to the building inspector's issuance of building permit number R-20-182, and that's for the reconstruction of what once was the house located at 488 Jerusalem Road. And I'll be referring to this as the raised house. The other appeal relates to the building inspector's failure to issue an enforcement order based on Mr. Stasko's first violation of the zoning bylaw and 2, violation of this board's special permit for construction of an addition. So the Wyndham's 2 appeals relate to reconstruction of the raised house and construction of an addition. But the construction that is currently—
Sorry, could I just interrupt you for a second? Are you going to compress your presentation on both appeals to one introduction, or do you want to deal with the second appeal separately?
Well, you stole my thunder.
Oh, sorry about that.
It was perhaps my no apology needed. It was my next sentence to say that there really isn't an addition and a reconstruction. There is one new construction that is underway. It is an entirely new residence. And now let me share my screen here. Just give me—
So you're going to basically compress these two. I mean, I think we understand if the building inspector has refused to issue an enforcement. But
Exactly, that's right.
But there are no, I mean, the facts of the, oh, okay, go ahead, proceed. I just wouldn't want to go over already covered ground, that's all.
I'm trying to screen share here. Let's see if this is effective. 1 second. I am. Let's see here. It's for some reason this is.
Well, you know, we do have plans, hard copies in our packet, so they may not be as user-friendly as what you're about to show, but you know, if you can't get that to work, we can at least refer to our
Are you able
packet.
to see?
I don't have a packet. Though.
Oh, okay.
I'm traveling.
All right.
So it would be better if we could see.
Obviously,
it.
yeah.
If we can't, we can't.
No, just give me 1 minute. Something to do with the program here. Okay. Now I am screen sharing.
There we go. I think you're up.
Yep, no,
1 second. Sorry for this. I need to stop share. One second. It turns out I need to open the PowerPoint presentation for it to find it. That was an older model. Let's see here. I think this is it. This is it. Here we go. Can everyone see the first photo?
I can.
Okay,
Pete?
very good.
I can see it.
Peter, you okay on this?
Yes, I'm fine. I'm fully connected now. I'm going to put it on mute some of the time, but I'll take it off mute to talk or when I'm being talked to. And I can see the house and the railing in front. Thanks.
Very good. Apologies. 1 second here. Having an issue with I need to get out of the screen. Okay, so the first photo that I was showing you is not an addition. So the basis on which the special permit was granted, that's section 300-8.7.2 of the bylaw, which permits an extension of an existing non-conforming structure, no longer applies. There is no addition that it would attach to now that the pre-existing house was demolished. And these are circumstances of Mr. Stasko's own making. When he demolished the pre-existing house, he was no longer building an addition. He should be required to reapply for a new special permit that fully covers construction of the entire structure. But let's set aside the fact that this is an entirely new project that requires its own special permit. What's more incredible here is the extent to which Mr. Stasko has attempted to sneak in significant expansions to what he disclosed to the ZBA. The changes he made to expand the structure from when he first applied for a special permit in 2007 to the plans that he submitted to the building inspector in 2019 to his actual construction show a clear disregard for not only the zoning bylaw, but also the ZBA and abutters like the windows. Now, his background: a special permit was required for the addition because of the property's nonconformities with respect to lot size, lot width, and front and yard setbacks, side yard and rear yard setbacks. He submitted architectural drawings detailing what he proposed to build, which I will go over shortly. Now, when the ZBA granted its special permit in February 2018, it expressly stated that, quote, any changes other than minor field changes must also be submitted to the Zoning Board of Appeals to ensure compliance with this decision, end quote. Now, let me walk you through the plans.
Does anybody else see any plans?
Oh,
Are you able to see the plans now?
no.
Just the photos.
Okay, here's a plan, proposed first floor plan.
So this is the 2017 floor plan, and
Okay.
it shows, if you, I'm going to use my pen here to highlight this. It shows an existing pad here, and then on the 2019 plans, that has expanded into a full office that's 2 stories, which you can better see here. So this is the west elevation, 2017, going to the 2019 plan. 2019 plan contains that 2-story gambrel bump out. It also contains a full 2nd-story deck and this dormer that's not shown on the 2017 plan. So again, going from 2019 to 2017, you don't have the dormer here, you don't have the gambrel bump out, and you only have a small balcony here.
Okay.
Now here's the proposed east elevation. Let me remove that mark. Here you have in the 2017 plan a 1-story shed roof. And then going to the 2019 plan, that has expanded into a 2-story gambrel bump out. You can also see the full 2nd-story deck, which I went over on the west elevation. Not only that, there has been a significant expansion in the as-built construction from even the 2019 plan. Here is the as-built foundation in the dark line going along with the pen. And it extends under the porches.
Is this the 2019 plan we're looking at?
This is actually an August 10, 2020
Okay.
as-built foundation plan. So this is what's actually on the ground.
Okay, that's actually in the ground. Okay.
And going back to the site plan, you see that there are merely footings in the 2019 plan running along this entire area. In the 2017 plan, again, only footings. So in this area, there is now a full-height poured foundation that makes room for, excuse my flipping, a full-height basement that you can see in this photo. So this is from Linden Drive. You see a poured foundation covering what appears to be the entire basement, which was never previously depicted on any plan submitted to the ZBA. So despite the requirement that Mr. Stasco submit any changes to the 2017 plans to the ZBA for review, he didn't do so. Instead, he slipped in the changes that we saw in the 2019 plans, in plans that he submitted to the building inspector to obtain a building permit. And even since that time, since the 2019 plans, there has been substantial change to that plan, including this full height basement. What I find particularly surprising is that in the meeting minutes to the ZBA hearings that were held for the 2017 special permit, Mr. Stasco is quoted as saying that, quote, expanding the house in such a way that it will not impact the neighbors. Their views will remain the same. The new space will be hidden by the existing, and then there's a parenthetical structure. I'm going to share the photo that I showed earlier.
But by the way, as you're searching for that, where did you get the 2020 as-built plan? Is that something you and your engineers calculated, or is this a plan on file?
That was shared with us by Mr. Egan, the building inspector.
Okay.
And my understanding is that is from Mr. Stasco's engineer.
Okay.
So again, Mr. Stasco, Mr. Stasco had explicitly stated to the board that abutters' views would not be affected. And when you look at the back half of this photo, that is essentially the addition, which is substantially intruding upon the views of the windows. And it is very close to the southwest boundary that abuts the windows.
Wait, when you say very close, what do you mean, very close?
So Mr. Cavanaro is going to be going over with you the properties of the boundaries. Just trying to stop there. I apologize for the technical difficulties. This is the program is giving me trouble compared to the normal Zoom sessions that I'm used to. Okay, so let me continue. So when it came to the building inspector. What he said is that he initially permitted the 2019 plans that were submitted, but then when it was made clear to him that this two-story gambrel bump out was included in those plans, he later clarified his position and said that, quote, permit issued on February 4, 2019 is only for the work that was approved under the special permit issued by the ZBA on February 12, 2018, based on the plans dated November 1, 2017. So no changes from the 2017 plans are allowed under the February 4, 2019 building permit. And yet Mr. Stasko continues to build a profoundly larger structure than he disclosed in his 2017 plans. Now I want to discuss the building permit that was issued for reconstruction of the raised house. Now that was permitted under section 300-8.9 of the bylaw, which allows a non-conforming structure to be rebuilt so long as it meets the following conditions. The first is that it's within the same portion of the lot. Second, the exterior dimensions do not exceed that of the original building, and such repair or reconstruction does not increase its nonconformity. Now, we can't tell whether he has satisfied those requirements because he's never submitted plans that ensure that the reconstruction meets these requirements. He instead has relied on his 2019 plan, which doesn't detail the dimensions, heights, or location of the pre-existing structure. Regardless, the 2019 plans show that the reconstruction of the raised house is in such a way that it unequivocally violates section 300-8.9 because it dramatically expands the footprint of the original building. You have the gambrel roof bump out, which increases the structure's footprint and adds a second story. You have reduced rear yard setback, which was already non-conforming. And Mr. Kavanaugh is going to show that to you via the plans. And a full height basement underneath it all, which increases the structure's exterior dimensions. So Mr. Stasko hasn't just violated one, but all three conditions on rebuilding a non-conforming structure under section 300-8.9.
Let me just interrupt for a second. Did he apply in 2019 then for a building permit under 8.9?
Yes.
Or was he still maintaining that he was applying under the 2017 plans as an 8.7 too?
Yes. So the reconstruction of the raised house is under 8.9. That's
well, did he apply for that relief? Well, there's no relief under 8.9.
Yeah, it's as of right.
Required.
So what he did is he demolished the pre-existing structure without a permit, then sought a building permit as of right under 8.9, and he has never established that the structure he is attempting to build in any way matches the dimensions, location, or height of that pre-existing structure. The 2019 plans were for the addition. So the 2019 plans did not specifically address reconstruction of the pre-existing house. And that's why it's silent on these key dimensional aspects that allow one to rebuild under 8.9. So these modifications to the raised house require a new special permit as provided in the bylaw. So with regard to the gambrel bump out, the building inspector initially approved the bump out because it complied with the under 15 average height exception, which Mr. Kavanaugh is going to go over. But he later correctly reversed himself. Mr. Egan, in a letter dated July 1, 2020, stated that the letter provides that under the 2020 building permit, quote, work is limited to the exact replacement of that structure on the same footprint and with no increase in vertical section or any portion of the building other than the proposed attic dormer on the east elevation that was shown on the November 1, 2018 ZBA plan. What is the exact replacement when there's been no plan depicting the location, height, square footage, or dimensions of the raised house? There's no way to verify whether Mr. Stasko is able to comply with section 8.9. There's been a wholesale lack of information and detail in the 2017 and 2019 plans relating to the reconstruction of the raised house. Thus, the building inspector, erred in failing to require Mr. Sasko to submit a new detailed plan showing all of these dimensions of the original raised house and the exact dimensions of the new structure laid over that plan. So as things presently stand, the Wyndhams and their engineer, Mr. Cavanaro, have absolutely no manner of determining whether Mr. Sasko is complying with the applicable bylaw.
Couldn't they go back to the 2017 plans as submitted to this board?
Let's take a look at the 2017. Let's take a look at the 2017 plans. And unless
No, I mean, you don't have to look at them as much as say, but couldn't you use that as your base point and then overlay or measure additions and increases?
I'm going to leave it for Mr. Cavanaro to address, but I can say
Okay.
this shortly. I can say this shortly, which is that the pre-existing house isn't depicted as having dimensions or a precise location on the plot plan or heights. So you can't determine from the 2017 or 2019 plan.
Because that wasn't before us. Oh, I see what you're saying.
Exactly. Only the addition was before you.
Got you.
Lastly, Mr. Sasko has failed to act within the time required on the 2018 special permit and the 2019 building permit for construction to commence. I articulated this more fully in our papers, and I'm not going to belabor the point. But ahead of those deadlines for both of those permits, he had only excavated, which doesn't qualify as commencing construction. So in sum, the facts demonstrate that Mr. Sasko is building an entirely new structure without the necessary permits. He has purposefully violated the bylaw's limitations on reconstruction of a non-conforming structure. He has also violated the restrictions this board placed on its 2018 special permit. To recall, the 2018 special permit specifically called out that any changes needed to be cleared by the ZBA, and that's clearly not what happened. Mr. Sasko tried to sneak in substantial changes through 2019 modifications that he submitted when applying for a building permit, and then in his as-built construction, which significantly deviates from the plans he disclosed to not only the ZBA, but abutters, and it's really requiring for him to go to the ZBA and apply for a special permit to cover this entire new construction. Construction should immediately cease, and he should seek a special permit for the entirely new structure that he's currently building. The changes that it contains are substantial compared to what he's previously disclosed, and they negatively impact the Wyndhams and their enjoyment of their property. I'm going to leave it now to Mr. Cavanaro to take us through some of the more technical details for why the changes in 2019 and the currently built structure exacerbate existing nonconformities.
Okay.
Thank you, Jason. Can everybody hear me okay?
Yep.
Jen, I'm going to share screen if that's okay. Everybody see that okay?
Mm-hmm.
Okay, so the Wyndhams and Mr. Curtin asked me to take a look at the file at 488, visit the site, take a look at the as-built locations, and review the plans of record through the current as-built plan, and asked me essentially to try to decipher what is being built compared to what was approved. So we took a look at, it's our understanding that what's currently approved is a rebuild of the existing building plus what was authorized under the special permit in the 2017 plans. As Mr. Curtin mentioned, there are no detailed plans of the existing house, so that was really nothing that we could review in detail other than what was on the submitted plans. So I'm going to walk through some just real specific things as it relates to yard designation, building height, lot coverage, as they're depicted on these plans. So first, the yard designation. What we're looking at is the 2017 site plan that accompanied the 2017 special permit application. So this called for, it designated a front yard, side yard, and it actually excluded any form of a rear yard at this location. It essentially called for a front yard on Jerusalem Road, a front yard on Linden Drive, and 2 side yards, one against the Wyndhams and one against the Milligans. So right away, that sort of raised a red flag, because we went back to a 28 decision that we actually had a similar case at 1 Jerusalem Lane, and the board was very clear and specific in their decision as to how to designate a corner lot. So this is really the interpretation that we've had since then on how to classify the yard designation on a corner lot. As I mentioned, we had a very similar designation, and in that, the board rejected the position taken in the legend of our plan that a minimum rear yard of 30 feet is not required on the subject lot. The definition of lot line rear in section 2 of the bylaw states that in case of a corner lot, the rear lot line shall be the line opposite the street on which the principal building has frontage. We believe that this definition is intended in the case of a lot bordered by 2 streets to identify just one of those streets, the one on which the principal building fronts or faces, as the place of the front lot line, and thereby to establish a single rear line. This eliminates the problem which would otherwise be caused by the wording of section 522 of the bylaw, and is consistent with the second sentence of section 524A. Yard rear is defined in section 2 as an open space extending across the full width of a lot line between the rear line of the building wall and the near lot line. The definition of yard required in the same section reads, with respect to any front yard, side yard, or rear yard, the distance required between the principal building and the respective lot lines for such yard in the table of area regulations in section 531. We believe that the correct application of these definitions is to the subject lot, which this is back at 1 Jerusalem Lane, requires that the Jerusalem Lane be recognized as the street on which the applicant's house fronts, and that the line separating the subject lot from the lot identified on the Cavanera plan as Bildzok, which in our case would be the Wyndhams, as the lot line opposite Jerusalem Lane, or in our case, Linden Drive, be treated as the rear lot line. To comply with the minimum rear yard requirement of section 531, any addition shall be 30 feet from this line. So this is really what we've been going on since 2008 as to how to designate a corner lot. I'm not familiar with anything different than that. So that's the premise in which I'll give you my thoughts on what's been submitted to date. The second thing is lot coverage. It's building lot coverage is 20% max in the Residence B district. This lot is about a 17,000 square foot lot. With the 2017 plan, they were proposing to increase lot coverage up to 17.6%, which is about 2.5% below the maximum threshold. It's unclear whether or not they excluded areas that are more than 45 degrees, if they exist, in this very steep slope corner of the lot at the intersection of Jerusalem and Linden. This is about a 10-foot drop in elevation and less than 20 feet. So it's more like a 1-to-1. It's pretty close to 1-to-1 in some of these areas. So I'm not sure if that was excluded. You can only use 50% of that real sloped area when you're calculating lot coverage. And lastly, just to make reference of the elevations, the first floor is just below elevation 45. Their average grade that they determined was based on an older survey, even from 2017. They based it on a 2009 existing conditions plan, and they came up with elevation 40. So what was approved in the 2017 plan was, you've seen these before in Jason's presentation, but this is essentially the Linden Drive elevation. So this is what was proposed as part of the 2017 plan within the front yard setback of Linden Drive. And interestingly, they call for this. It's very difficult to read, but on these plans, they have this area designated in the front as a non-work area. I'm sure it has something to do with tying into the existing building, but it also may reference, because it's on the 2019 plans as well, the change in the foundation type. The rear elevation was not extending to the south whatsoever with building. It just had that single story shed bump out. So as Mr. Curtin mentioned, the foundation was clear in the 2017 plan to just include an addition that was fairly modest compared to what's out there today. It was articulated as 23 feet from the front line of Linden Drive for the proposed addition, and this was all on sonotubes. So this was not full foundation. This was not considered structure below grade. And what's out there today is a foundation that is full depth foundation on the front, all within the front yard setback. Full depth foundation where the sonotubes were proposed. And notably, what's shown on the as-built location as about a 2-foot jog in this area, this doesn't appear to exist visually, just by observation from the Wyndham's property. I mention that because getting back to lot coverage, now that we have full foundation here, instead of just sonotubes, this was always covered porch, but this was proposed as a deck. So now this will come into play for building coverage.
Mm-hmm.
And if this is even off by a foot or two, this could also start to factor in.
When you say start to factor in, what do you mean? Exceed 20%?
To get to that 20%, right? They're
Get
2.5.
to it or get beyond it?
I can't measure that because
Okay.
I can't.
In other words, they could be a nonconformity could be created here.
Correct. They're getting close. It's a small lot, so they're about 400 square feet away from upsetting that 20% limit.
Okay.
So we're starting to increase building coverage here, and now we have a foundation in the back corner that was not proposed to be any type of roof structure in the 2017 plan. And now what's happening is, depending on the yard designation back here, if this isn't consistent with the previous rulings of the board in that this would be a rear yard, that takes away any potential for single story exemptions within 15 feet. This would all require relief from the Board of Appeals to actually keep what's out there today in the ground.
Could you go over that point one more time, John?
Sure. So right now, the applicant has proposed and certified that this is a side yard, this yard here. So they're claiming that by right, they have the ability to build a structure of which a portion of the main building, less than 15 feet in height, shall not be any closer to the required 20-foot setback, because that's the exception in the bylaw for a side yard. But a rear yard doesn't benefit from that exception, as you noted in the one Jerusalem plan.
So if at the top of this picture is the side, the rear is being violated, you're saying? The rear
Correct.
setback.
This would be the rear. If we're consistent with the one Jerusalem plan, this would be a side.
Okay, so they don't.
So any expansion of this building within that rear yard would require relief from the Board of Appeals, regardless of height.
Okay.
Additionally, this new foundation wall would also be within the rear yard, as is this new foundation wall that's in the front yard. So even this foundation wall in itself triggers additional relief, another look from the Board of Appeals, because this was sonotubes on the original application. Now it's full depth structure. So going to the 2019 plan to try to reconcile between what's on the ground, what's on the as-built plan, what was originally approved, and what potentially could trigger additional relief. again, looking from the Linden Drive side, it's clear that, you know, they still were calling this a non-work area in their 2019 plan and pointing to the ground, meaning they weren't planning to disturb this, I assume, I'm not sure. But now this is all full foundation in this area. And you can see, as Mr. Curtin pointed out, this is a second level that's been expanded within the front yard setback of Linden Drive. And it's also now building because instead of being a porous deck that was supported on sonotubes, this is now a full foundation wall that will have a roof. Additionally, and again, we're just guessing on some of this because it's under construction and we're not sure if this is the approved plan or not. But this dormer would also be sited within the front yard setback. So that would trigger some additional relief request from the Board of Appeals. And then lastly, in this elevation, we're looking at that bump out to the south, which I want to talk a little bit about in this elevation. So talking about height, we've always been under the impression that we have one average grade that's used to measure height of a building. And that average grade is determined around the existing and proposed footprint of a structure on the existing grade. So if we have a 100 square foot box that exists and we want to add another 100 square foot box, we'd have a 200 square foot loop around the existing grade. And I have to take the average from the sidewall of the foundation within 10 feet. And if it goes up or down, I take the average, and that's my average grade for the building. That's how I measure height. In this set of plans, it was curious because they have this secondary, they have two grades that they're referencing, that they're measuring height from. One is the approximate average grade, whole house, including garage at elevation 40. And then on this rear portion of the house, they have rough calculated average grade at south side of kitchen. So in this average grade is much higher. It's about 4 feet higher than what the whole house average grade would be. I know it's about 4 feet because it scales to be within about a foot of the first floor elevation, which we note on the site plan and on this plan that it's 44.9. So it's probably around 44 is what they're measuring back here, because that's about the grade behind the house. And if we were to call that 44, we're about 4 feet above the average grade. Tack that on to the dimensions that are on their plan, and we're well above a 15-foot height designation, even if the board were to reverse their previous opinions on how to designate yards on a corner lot, and they said that this was a side yard, we'd be clearly in excess of 15 feet for this bump out, if this is what is being constructed to the rear of the house. So this is not a questionable, how do you measure to the midpoint of the roof and so forth. This is straight roof going right up. This is what it looks like in the other elevation. So you'd measure to the top of that roof. I think it even gets too big on the side, on the side yard, because the bylaw reads that for portions of the main building, less than 15 feet in height may extend within the setback. Well, there's a portion of this building that's more than 15 feet in height that extends within the setback. So I'm not sure this passes the test either, but clearly this does not pass the test of less than 15 feet in height. But based on previous decision, I would say that the rear yard would come into play here and knock this out completely, or at least require relief under an amended special permit. So that's essentially what I had to go over in terms of yard setback, height designation, and substantial deviations from what was approved on the original plan and what's actually out on the ground today. I'm happy
Interesting. Okay.
to stop share. I'll stop the screen share unless anyone has.
Do people have questions for either Attorney Curtin or John Cavanaro, or should we hear from the other side and then fire away? Peter?
I have a question for John. Can everybody hear me?
Yeah.
Okay. John, there was a 400 square foot area delta, I think you mentioned. I want to be clear what that delta was. Was that the difference between the 17.6 and the 20% coverages based on the original plan and the maximum permissible under the bylaw?
Yes, what that is it's essentially 2.4% of 17,338.
Thank you.
Now, if there are no more questions, I know that John Wyndham would have liked a chance to speak, if that's permissible at this time.
Sure.
I'm going to promote Mr. Wyndham now. Oh, he should be there now, actually. There
Yep.
it is.
Proceed.
So I'll make this.
Your volume?
Can you hear me?
Not well.
It's fine. I don't want to hold things up. You can just move on.
Okay, well, you'll have a chance. We'll come back if you want to make comments. Okay, so Attorney Curtin, willing to turn it over to Mr. Stasko's representatives to give his side of the story?
Yes.
All right, I'm just promoting Mr. DeLisi at this point, Attorney DeLisi. If Attorney DeLisi wants anyone else promoted, he can let me know.
Hey, can you guys hear me?
Yep.
Okay, great. Thank you very much for holding this special hearing this evening. We appreciate it. Jeff DeLisi of Ornberger, DeLisi and Harris. I'm here tonight with Ryan Stasko, who is the property owner of the property in question, along with our architect, Steve Noonan from Axiom Architects. And there's quite a bit of information in that presentation that I did not see in the paperwork. So what I had planned to do was to review kind of the factual situation from kind of the inception of this to now, so that the board can understand, chronologically what has occurred, conversations that occurred during that period of time, and our position on this appeal. And just to kind of step back, our appeal is related to the letter of Bob Egan dated July 1st of this year, wherein he indicated that the work done pursuant to the special permit that was issued in 2018 can commence under that building permit, that the work done in accordance with the reconstruction permit that issued in 2020 can continue, and that if there's any deviation from either of those two plans, Mr. Egan indicated that the owner would have to apply for a new building permit for those deviations. And so kind of at the outset here, just to step back, the property we're talking about, 488 Jerusalem Road, is in the Residence B zoning district. As John indicated, it's a corner lot. The lot is non-conforming as to lot area and lot width. There is a front yard setback non-conformity off of Linden Drive. Otherwise, our interpretation and what we've been going on, and I'll get into that slightly with Bob, otherwise we didn't see any additional nonconformities. And I know that the board was not looking at that specific issue on the side yard and the 15 feet at the time of the special permit, But there were plans that were filed at that time, and there were notations made in the zoning bylaw, in the zoning decision, that indicated what the findings were with respect to setback nonconformities. So the issue that we have focused on is the portion of the main building that's less than 15 feet in height and may extend no closer than 15 feet to the sidelines of the lot. The ZBA issued its decision in February of 2018. And at the time, the issue was that the proposed addition would be off of the front of the building from the frontage road of Linden Drive. And that front yard setback there, as we've all indicated, is non-conforming, which was why a special permit was required under the town's bylaw. Mr. Wyndham's lawyer has properly indicated, the condition of approval in the zoning permit was that any changes other than minor field changes must also be submitted to the ZBA to ensure compliance with this decision. So following that decision, and this is kind of where I step back and I just very respectfully would like to take a disagreement with the multiple characterizations that my client has tried to slip in changes last minute and so forth. That couldn't be further from the truth. After the zoning decision was issued, the concept was, geez, maybe we can get some more comfortable space if we raise the roof off of that westerly side yard, which John thinks might be a rear yard, in order to match the roof line of the proposed new addition. And that would be about raising the building about 2 feet. And so the proposal was brought to Bob, discussed with Bob. Bob concurred that we were not creating a setback nonconformity if we were to do that, by virtue of the application of the footnote to the zoning chart that allows you to go within 15 feet at 15 feet in height. As a result of those discussions, building permit plans were drawn up, and which included this particular bump out, and the decision was to issue the building permit at that time. After the building permit was issued, contrary to the Wyndham's assertion, I didn't hear them raise the issue tonight, but it was raised in their paperwork. The permit was properly extended in August of 2020, prior to the 6-month expiration of the building permit's issuance. Within that 6-month extension period, in the very beginning of January of 2020, the work had already commenced. Both interior and exterior work was being done, and they were full on at that point. And in the month of September, excuse me, let me back up. Prior to commencing the work, in the month of October of 2019, I believe, and Bob could indicate whether he concurs with this, I saw some email correspondence that indicated that the matter was brought to his attention at that time for the first time from the Wyndhams concerning the bump out. And he was provided with an explanation from Mr. Stasko based on his investigation of the question, and was provided with plans, which he shared with Mr. Wyndham's representative at the time. It might have been a landscape designer, I'm not sure. And nothing was said of the issue after that, as far as I know. So the work commenced thereafter, and in the spring of 2020, as we were doing the work, it became evident that there were some very serious structural defects on the foundation of the then existing house. And I'm going to call it an existing house, even though it's been raised. And at the time of this discovery, there were conversations with Bob about that particular issue, and the determination was made that it was the only sensible decision was to raise the house, re-pour the foundation in the same spot, and go up from there. Bob specifically indicated in correspondence, and I think he would concur, that this issue of the zoning bylaw concerning damaged buildings being able to be constructed as of right within the non-conforming setback area, so long as they stay within their vertical plane, that was discussed with Mr. Stasko, and Mr. Stasko was clearly told that you can do this as of right. I'll issue you a building permit. And so I believe that the decision, I know that a building permit issued in June of 2020, as a result of that, Bob was given the foundation as-built plan of the house that has just been raised, which foundation was still there after they raised it. And they were able to determine that the house is in the same location, that the foundation will be poured in the same location as the existing foundation. And so that was done. Bob was notified on multiple occasions when the foundation pouring was going to happen. At that time, the Wyndham's lawyers had begun investigating the issue. Bob was sharing full plan sets with them that he had, and being the gentleman that he is, he indicated that he wanted to clarify his position and now require a new building permit, even though one was already issued with respect to that particular bump out. And if you look at the building permit from 2019, what you're going to see is that it specifically said on the face of the permit that it authorized the front and rear additions. Now, with respect to, so what we're asking the board is to honor the building permit that was issued in 2019, which we are entitled to rely upon. I think that tonight's presentation is evident that there is an attempt to make kind of a second bite at the apple on an appeal process. This is the circumstance that was presented. There was no intention here to flout the zoning bylaw. I'm sure Bob can talk to the interpretation on the corner lot question and the side yard setback, but he already made the determination to accept that interpretation way back in 2019 when he issued the building permit. And that's specifically the reason why we have filed an appeal of his July 1st letter to kind of go back on that, because here we are. And so that's kind of where we see this. He did file a full Merrill plot plan by Merrill Associates back in 2017 with the permit application, and then I believe it was revised in the year 2018 during the hearing process. And the board has that plan in its file and can match up the foundations there. We can use that to understand where the vertical walls will be. There is no height nonconformity on this property right now, or previous to the raising of the house, and there will not be one when this house is reconstructed. The argument that that this is a totally different, that this is a different permit once the house is raised is contrary to general accepted zoning principles. When you issue a raise and reconstruct permit, which you do all the time, the permit doesn't all of a sudden go away once the house is raised and before it's reconstructed. So we have a proper building permit to reconstruct the existing house in its location. We think that the board should uphold that. We have a proper building permit that allowed the bump out and made the call and the interpretation that we're not creating any new nonconformity. We're not intensifying any existing nonconformity. Otherwise, the permit couldn't have been issued.
Well, Jeff, you can make that claim, but what if the height of that bump out, using a different grade, not the 40, but the 43 or 44, creates a nonconformity? Bob doesn't have that authority, does he? Does he have the authority to authorize the creation of a nonconformity?
No, Bob
Does he have the authority to authorize the creation of a lot coverage nonconformity?
No, and that's speculative.
It may be, but I think it's also calculatable and ascertainable. And if there's no nonconformity, fine. But if a nonconformity is created, that's your lookout, not anybody else's.
I understand that, and I agree with that, Woody. But right now, we're not proposing a nonconformity, and the building permit was issued on the basis that you can't create a new nonconformity. And so the only way to ascertain that is after the building is built, right? And we know what the coverage calculation is or what the height is.
We can figure it out now. The building isn't entirely built.
Well, agreed. And we have Steve Noonan from Axiom Architect who can explain.
Okay, fine. I don't want to jump in front of your presentation, but
No. All good questions, Woody. I'm trying to answer them as best as possible, and mindful of the fact that for the very first time 5 minutes ago, I heard that there's a speculation that there could be a building coverage nonconformity here. I think that I'd like to hear from Bob. I think that Bob, he's inspected this site after the house was raised, after he received the foundation as-built plan the corners were pinned by Merrill Associates, so he was able to see that clearly. And I think that Bob might be able to give some background.
well, I think we can come to Bob after I sort of jumped in to your
Yep.
presentation. And if you want to have Steve Noonan or others speak,
Yeah,
amplify your points, I think they should go first.
absolutely. I just want to make sure that the board understands, and I also provided the board with a copy of a case that I'm sure this board has already reviewed on multiple occasions that indicates very clearly that if you're not creating a new nonconformity, and if you have a small scale addition, by law, you're able to do that as a matter of right on a nonconforming lot. And essentially, that's really what Bob made the call on here. And so I think that this is all coming down to whether the board can honor the existing permit from 2020 and whether, based upon Bob's determination that he had the information in front of him to make the call, and whether the board whether the board agrees with Bob's interpretation in 2019 that it was a slight modification. And I also included in my packet, I think it was the second to last exhibit.
You're talking about the Bjorklund case?
Well, I have the Bjorklund case, but prior to the Bjorklund case on let's see here. On Exhibit E, I have an email from Bob indicating, per our conversations in the letter that I sent to Mr. Stasko today, this is dated July 1st, I confirm that I believed at the time that the slight modification complies with height and setback requirements. So, we have very clear, that the call was made, and I'm aware, that there are many aspects of zoning in the town of Cohasset and other towns on the South Shore throughout the Commonwealth, wherein zoning boards aren't entirely consistent from case to case. And what the court has ruled on that, and I think all counsel would agree, is good law on this, that that one case doesn't create a precedence over another. Each zoning case is to be determined on its own merits. Now, just kind of separate from that, let me just take a quick peek at my notes here. I'm just going to review these as Steve takes the mic, and I had a point that was a brilliant point that I somehow seem to have lost. So hopefully I'll get it back.
Okay.
But
Just
Steve,
raise your hand when it comes to you.
thank you. Well, now I'm under the gun that it actually is brilliant when in fact it's probably not.
Attorney DeLisi, is Mr. Noonan under Abigail? Is he under his, because this is an Abigail Noonan.
Yeah, he's under Abigail. Yeah.
Okay. All right. I'm going to promote him now to panelist.
Thank you.
Hello?
Hello?
Can you hear me?
Cannot see you yet, but
Yeah.
we can hear you.
All right, here I am.
Great.
I am not Abigail. That's my daughter. I don't know why I came up with that. It's happened to me with my other daughter as well. So, yeah, I mean, obviously, let me just see if I'm going to share something if I can.
I've given you sharing capabilities.
So what we did, what Ryan and I did before, as we were, trying to put this through and draw it properly and put it before Bob, is we took the average grade to determine that the building height of this rear addition would be conforming to the 20-foot side yard setback on both sides. We determined that we were taking the building height or the average grade, which we calculated around the perimeter of the part of the structure in question. So I offset a line 10 feet from the foundation line of the existing footprint, which I did include that there's an existing concrete pad there along with the kitchen, the rear kitchen bump out. And along each of those lines on that offset line, of the grade elevations, I measured along the perimeter to calculate, if I come down here, to put a chart together where I took each grade elevation starting with 39 and measured, say, 10 feet of grade elevation 39, multiplied that into the third column, and so on and so forth as I got up to contour elevation 47. And once I got those 3 rows set, I did some quick math and basically came up with a total for column 3, a total for column 2, and divided column 3 to column 2. And I came up with an average grade for that section of the building at 44.93. And then if we go over, I then placed that datum line of the 44.93 on the elevation in relation to where the first floor was or is, and measure up to the midpoint of that gambrel and come out at the 14 feet of the building height. And then even at the peak, which you can see that the peak is outside of that 20-foot setback line, is at 19 foot 10 3/4. If we took it at the actual 20-foot line, we would be around 19 feet. And the midpoint would be a few inches lower. That's what we were basing it off of, that average grade. And as far as I knew, that was being accepted. So,
Well, why do you say that?
why was it being accepted?
Being accepted. Why was it being accepted?
As far as I knew, our client went to Bob and confirmed it and got the permit, and to us, that's saying, okay, it's been confirmed. So and we went with our client's word and with the building permit issuance.
You may not have paid attention to the definition of height in our bylaws then. A building has an average grade. It doesn't have different average grades depending on where and what you're doing.
Yes, I heard that from John, and when we first started this out, this rear addition bump out, I believe our client went to the building inspector and confirmed whether we could take.
Do we
the
have that in
building.
writing?
I do not know the answer to that. I'd have to talk to Ryan
All right.
or ask Ryan to see whether he got.
I'm not
that.
interested in hearsay. If it's in writing, fine, submit it.
Okay, we can talk to Ryan. I don't know if he's going to be speaking on this, but I believe he's present. But that's where we were at on this. I just wanted to confirm that with the average grade. The corner lot 30-foot setback is new news to me, because I know when this went through the zoning a couple of years ago, they were still considering this to have 2 front yards and 2 side yards. So we were using the 20-foot side yard setbacks on both sides. And Jeff,
Can you guys hear me?
Yeah.
Oh, great. So it's a couple of brief follow-ups on this. So Woody, when you ask for it in writing, I'm sure Ryan would sign an affidavit, but I think that the fact that the building permit issued based on plans would indicate that Bob agrees, and that's the writing and all the writing. I think that's necessary. But aside from that, I wanted to make 2 points. One, on the issue of views, okay? The only thing that I heard tonight in the presentation on behalf of the Wyndhams is that there's a concern that about views. And I think that the board understands that in the town of Cohasset, views are not a protected interest under the town's local zoning bylaw. In addition, on the issue of Bjorklund, I just wanted to read to the board what the Supreme Judicial Court says on this issue. And that's on page 6 of the Bjorklund decision. It indicates concerns over the making of small-scale alterations, extensions, or structural changes to a pre-existing house are illusory. Examples of such improvements could include the addition of a dormer, the addition or enclosure of a porch or sunroom, the addition of a one-story garage for no more than 2 vehicles, the conversion of a one-story garage for 1 motor vehicle to one-story garage for 2 motor vehicles, and the addition of small-scale proportional storage structures such as sheds used to store gardening and lawn equipment, or sheds used to house swimming pool heaters and equipment. Because of their small-scale nature, the improvements mentioned could not reasonably be found to increase the non-conforming nature of the structure, and we conclude as a matter of law that they would not constitute intensifications. And Woody, I understand your point is that, well, if you're creating a nonconformity, that, game over there. But this goes to the issue of the existing nonconformity being on the front yard. And not to put words in Bob's mouth, but I did talk to him about this and he can speak to it. The issue was that the reason for the zoning special permit had to do with the addition or the intensification within the front yard setback off of Linden. And so if we had simply proposed to do an addition on the rear and not the front yard addition, and that was considered at the time, as it was at the time, to be a side yard, there would have been no need to go to the zoning board for that. based upon this decision of the SJC. So I think Bob was correct. I think it was a minor or a slight modification at the time. And so we have to go back at the time. And any of the other modifications really were with respect to the issuance of the 2020 permit concerning the reconstruction. So Ryan, did you have anything that you wanted to say, or should we maybe ask the, turn it over to the board?
I just promoted Ryan. He wasn't part of the panelist.
Right. All you have to say is yes or no.
Can you guys hear me now?
Yeah.
Yes.
Okay, I'm sorry about that. No, Jeff, I think I'm good. I think we can turn it over to the board.
Okay, thank you.
If anything else at this point, a board, any questions before I ask Bob to speak, of Jeff or Steve?
Nope.
Okay, well, be plenty of chances. Bob, you want to speak, please?
Okay, it's a little difficult to follow, and I think you've all picked it up pretty well. As you know, the special permit was granted in 2018. No appeal was taken to it, no objection. It apparently went through the board. It took a couple nights, but the board issued a decision to allow the special permit because of the proximity to Linden Drive. And the board issued the decision. I'm not sure of dates, but before the expiration of the special permit, a building permit was issued. And at the time, just as everybody, both sides have said, I considered that that bump out to be, after I spent some time going over it and understanding how they came out with that 15-foot exception, I consider that to be having nothing to do with the special permit. In my mind, it complied with zoning. It met the exception for the under 15 feet, which allowed it to be 15 feet in a side yard. At some point after that, Mr. Wyndham, questioned me on it, and it became apparent that that was a real concern of his, and I could see why it was, and that it didn't come up in the special permit hearing. He was not aware that this was being proposed, and it seemed that he should have been. And that it would have been reasonable for him to have had some input into this, to ask some questions about it. And I spoke to his attorney several times about that. And then, as we all know, as the construction went on the addition, mostly putting in the foundation, that's when they discovered that the building, the existing building, was beyond repair. And I issued a second permit for raise and reconstruct as allowed in 8.9. And there were questions about that from Mr. Wyndham and his attorneys. So I took the position that the special permit, the building permit that relied on the special permit should be just for that work. That would make that very clean. It wouldn't have to get into the question of the compliance of the addition. The permit to raise and reconstruct the original structure, to me, was very clean also. It was duplicating what was there, and that's what 8.9 was specifically written for. It seems that when you have a building that is beyond repair, you can repair it. You can repair it and or replace it in the same portion of the lot, in the same vertical section. And the letter I wrote in July 1st was, the 2 building permits allowed 2 specific activities to take place. Anything beyond either what was replacing the existing structure or the work authorized by the special permit would require a separate filing. And to me, that we could have had this discussion, and we could have, we could have had, in this case, maybe John Kavanaugh having one opinion and Steve Noon having another, and maybe resolving this before it had to go to an appeal. But I'm not surprised that it is going to an appeal. I don't think there's any question that the rest of the building permits were correctly issued. I don't see, and a few issues were raised tonight that I hadn't heard before. I don't think that putting a foundation in a full basement underneath a permitted structure actually changes it. It certainly doesn't change it from appearance-wise or effect on neighboring properties or the view from the street. When it's done, it will be done, and no one would know the difference. So I don't see that that's a change from what was issued on the original permit. Now, as to in this case, only come to for the first time tonight to me too, whether that's a side or a rear line. I've taken the position, and I think, and John correctly showed something from years past, but I've taken the position that there are, when you have two fronts, then you too have two sides, because the side lines on most streets typically line up with each other. My side is my neighbor's side, is his neighbor's side, and so on and so on. So the sideline on the Stasco property that lines up with the Wyndham property is also Mr. Wyndham's sideline. The sideline on Mr. Stasco property that lines up with Mrs. Milligan's property is also the sign line. So it doesn't seem to make logic that he would have to consider the back line to be a rear when it in fact lines up with the Wyndham side. But that could be, obviously that will come up in discussion. But further to that, when Mr. Stasco did come for the special permit, the board, if they had taken that position that was a rear line, they would have had to have given him zoning relief from the back of the building also, because that would have been within the so-called rear setback. Excuse me, that never came up in discussion. That relief was never asked for. The board never identified that as something that would have to be granted a special permit for. It seemed that they considered that to be a sideline also. I don't know if there's any other specific questions that anyone has.
Board?
I have a question, Bob. On the issue of the deck and with the new second floor deck over it, does that not in fact increase the building coverage?
Oh, I would think that the original deck counts as building coverage. And I don't think it changes it just because there's a roof over it, because I think the original deck would have and should have counted as building coverage.
Okay, so you see any increase in the building coverage calculations on what's being built now as opposed to what was on the original plans?
No, I think the size and shape of the footprint of the building, both the existing and the new construction, are as it were, and as what was approved by the board.
Dave, let me just jump in here. But Bob, what about coverage maximum permitted, the portion of the lot covered by any man-made materials that are impervious to water? And if you've got a deck over ground, that's not really impervious. We've ruled many times in the past that doesn't count as lot coverage. But once you make it impervious,
I'd like to know, I never, again, this lot coverage just came up tonight. I'd like to know, maybe John Kavanaugh, who brought it up, could tell me whether he considered, or could tell the board, whether he considered the original deck to be lot coverage, or he only considered it lot coverage when the roof went on it.
Okay.
So, a couple things. That's exactly was my point, that in the past, and I'm here primarily to get questions, as you can imagine, moving forward. This is all about objective decisions that are going to set precedent for what I essentially do on a daily basis. As much as I respect and appreciate my clients and the neighbors and all that's involved with this, I'm really, really interested in how to get these decisions determined and how to do the same thing over and over again correctly. So as far as yard designation, it was very clear in that 2008 decision what you folks just decided on, how to determine yards on a corner lot. So that's that. I can provide you with the 2008 decision, but I'm more than interested in hearing how to proceed with that. As far as changes and what would trigger relief, absolutely. I would have assumed that, and I can't verify this based on the evidence that's been submitted, but I would think that the deck, what we have always used for building coverage, would not include a pervious deck, would not include a deck that was founded on sonotubes. That would not be part of building coverage and anything that I would calculate for building coverage.
John, I can't remember a case where the opposite would be true. I don't recall one case where we considered a deck with pervious decking to be part of lot coverage.
Right. It's basically anything with a roof. And now that there's a full basement underneath that deck, it has to have a roof, of course. So that would now fall into building coverage, as would the addition on the southwest corner. That was not part of the 2017 special permit. Call it de minimis or not, there was no roof there. So now that obviously will be building coverage. An impervious patio is not building coverage. That's part of total lot coverage. So the building coverage, 20%, lot coverage, 30%. So building coverage is anything with a roof. So that the addition in the back would trigger additional building coverage. Whether or not this exceeds the 20%, I don't know. My point is that we're within about 400 feet based on the evidence that was submitted. So any change matters. And, even in the foundation as-built, they show a 2-foot jog that visually just doesn't exist in the field. Maybe there's something there that I'm missing. And then lastly, just in terms of, there's been a point about not creating any non-conforming height issues. Again, all due respect to Steve, I do a lot of work with Steve. He's a great architect, as is Jeff, an attorney. But I just want to, even in Steve's words, the way he calculated that average grade, it's just not what we do. Historically, we don't do portion of the building as average grade, but even if we were to do that, he was clear that the height to the peak of that gambrel that faces the windows is about 20 feet. Well, there's no subjectivity there. I don't measure to the midpoint of any roof when it's a vertical wall facing a sideline, whether it's side or rear. It's 20 feet tall within the 20-foot setback if it's a sideline, and it's 20 feet tall if it's in a 30-foot setback if it's a rear line. So I probably answered more than I should have.
Yeah, that's good. Hey, Jen, can you get me back to, or my screen or everybody's screen back to looking at the participants in general?
So whoever was sharing that Zoom, it's someone who's sharing their screen. That's not me.
Oh.
So I think, I'm gonna, there we go.
There we go. There we go. No, it's just nice to see that.
No, I was trying to figure it out, then I realized it wasn't me, so there we go.
I don't blame you. Okay.
I know, please do.
Now, how about the board having questions of Bob? Okay. We've heard from all three.
Woody?
Yeah, sorry, where are we? Oh,
That's
Jeff.
right. Yeah, no, I just put my face back up. I just wanted to, since we were talking about Bob, just amplify the point that Bob made. which is that, you know, if the interpretation of the special permit, which has become final after no appeals, was that because it was a corner lot, a rear yard, that, you know, that should have been made in the decision. And the fact that it wasn't made in the decision, I believe respectfully constitutes a final determination by the board on that matter concerning this project.
May I speak up to that point?
Sure, go ahead, Jason.
That may well be true if there weren't subsequent changes that Mr. Sasko is making to the structure, and he's done that. So we're not really operating under the 2018 special permit, given what Mr. Sasko has built.
Actually, I do have a question, Bob. When you were looking at the addition, the bump out, whatever you call it, with the gambrel roof, when you were looking at it as whether or not it was 15 feet or less, were you using the grade that they gave you on the drawing of 43 or whatever it was?
Yes, the grade for the area around that proposed addition.
Okay. What's your assessment of John's average grade? John Cavanaugh told us that the average grade for the whole envelope is what should be used. Is that right, or do you use?
I think there's logic to both interpretations. I mean, it on a house like this that it is such a difference in grade from the high point to the low point that on a portion of the building, a small portion of this, that it should be the area around that small portion, not going all the way basically down to street level and then up quite a bit higher when you're trying to figure out, is that 15 foot going to have an impact? I think that it makes sense to take the average grade from around the area of that the proposed addition, not around the whole building. But I don't, but John's interpretation is as good as mine.
It seems to me we need to have a consistent.
Right, exactly. That might be one of those things that we should be defining more closely.
But again, there may be, I'd be interested in if either side could, or Jeff, if you could come up with examples of this board deciding that height was measured only on the portion of the yard on which a structure was being built, as opposed to the total structure. The bylaws, yes, you could interpret it, I guess, a couple of ways, but it says within 10 feet of the outside walls of the structure. We have typically, I believe, taken the structure to be the totality, but I could be wrong. Could be absolutely wrong.
From a logic perspective, I would find it hard to set any sort of standard with regard to a section of a structure as having an average grade. How do you demarcate what is in bounds for a particular part of a structure? Only looking at it holistically, could it really be standardized?
So I've never run into this issue in the town of Cohasset. I can look, but I haven't run into it. I certainly think that given these additional arguments that are being made tonight that were not previously made, I certainly want to look into many of them.
I respectfully disagree. I don't think there have been many new arguments presented. We did submit a fair number of pages. I certainly admit that. So I respectfully disagree that there's any.
Okay, but that's not the real. I mean, we are obviously going to continue this hearing, and there will be opportunity to respond, point counterpoint. So whether it's new or not new, you may want to give it a new interpretation. I don't know, but if with the agreement of the board, I'd like to find out if there are people in the audience who'd like to speak for or against, or just request clarification. Jen, do we have anybody in line?
I do not have anybody that is raising a hand to speak via Q&A. I did receive 2 emails late this evening. Actually, one during the meeting, one not right before the meeting. So I will forward that to both attorneys as well as the board, but I could just give you a brief synopsis of what the content was and who sent
Great.
them. So one is from Megan Driscoll. She lives on 141 Linden Drive. And the construction site has been an issue for anyone living in our neighborhood. I reside at 141 Linden Drive. She has no alternative access to her home other than passing the construction site. And on multiple occasions, that access has been blocked by equipment and traffic for different vehicles entering and exiting the properly. So she knows that she just would like some aided traffic flow. So that's more of a construction on site, but that's her comment. And then we received around 8:45 a letter from Brett Regan, who lives at 7 Linden Drive. And he is saying that the current construction doesn't sit within the former foundation outline. And he asked if this went through the large home review. And so I will put those in everybody's files.
And I don't believe it's gone through large home review because I did read something that said it was less than 3,500 square
That's my
feet. I don't know
understanding.
if that's been calculated or not. And
Well, that's a good point, Woody. It seems to me that it's almost impossible for us to figure out whether there's any issues for us to think about without an engineered stamp plan.
right.
I mean, we're just speculating about everything right now, and it just before we look at this again, I'd like to see one.
And prepared by Mr. Stasko and his crowd, stamped.
Yeah.
Yeah, because obviously the Wyndhams don't have access to.
And with the calculations of lot coverage and building coverage and elevation.
Precisely, and if the bump out or if that little jog doesn't exist, included as part of lot coverage,
Right.
so on and so forth. Yeah, I'm not too interested in whether a building permit was issued or not. If the plans have changed and one or more nonconformities were created, then I think there's a big issue, a big problem. But we don't know yet. Jen?
Would you like to see if special counsel Cindy Amaro would like to
Yeah,
speak to this before? Because we still have 2 other hearings, and I just don't know what your next steps are going to be, so we'll need to discuss
2 other
that.
hearings tonight?
Yes, we have 2 more appeals. We haven't opened the other 2 appeals, so this is the first appeal. Now we need to open the second appeal and the third appeal.
I don't think there's any new information in either of those appeals, is there?
Well,
We haven't covered?
you'll still need to open them, and then
All right, I'll open them, but I mean,
right, yeah. So if we could just at the see now, it's up to you if you
I
want
mean, those are going to be short discussions.
Right. I just wanted to make sure we follow procedurally. That's all.
Okay, that's fine. So, Counselor?
As I just discussed that,
Right.
are you referring to me or someone else?
Well, go ahead. I was referring to Ms. Amara, but
I just wanted to clarify, as I mentioned before, that we consolidated our appeals in our initial presentation, so we'll have nothing to add to the appeal once it's opened.
Okay.
well, Jeff will come back to you. But I mean, if there's new information on either of those 2 appeals you have to submit tonight, fine. Otherwise, I think we'll open and continue them quickly.
Yeah, I have no,
But I don't want to cut you
Okay.
off. I mean, if you've got,
no objection at all. I think that we've engaged this conversation, this discussion the right way. All these 3 appeals all have to do with the same set of facts and circumstances. And we've all touched on them across the board during our presentations and questions and answers. So no objection whatsoever.
okay. Well, Jen, we will open and continue
All right.
those. But
And I apologize if that was addressed at the beginning of the meeting. I did lose connectivity twice.
okay. So, Cindy, would you care to say anything at this juncture? Wait, you're muted. You're muted. Go.
Maybe I should stay that way. I don't think I have too much to say at this juncture because sitting here listening to the presentations from everybody, I agree that there seem to be some basic factual elements that are missing that I think we need to have before us before we can go any further to determine what was really before the building inspector, what was really before the board before, what is really on the ground now. And in order to really look at how different this new building is from what was there and from what was originally anticipated to be there from your decisions and the building inspector's decisions, to me, I think numbers and plans are key before you can really go much further.
Yeah, I think there are three sets of plans that we need more information on. The first of which is, ironically or not, the 2017 set of plans where we were not dealing with issues of height, lot coverage, et cetera, setbacks per se, but merely the proposed addition. But I'd like to see dimensions on all four elevations, vertical, horizontal, et cetera. And I'd like to see the same on the 2019 plan that Bob approved in the 2020 as-built plan with some sort of shading, coloring, cross-hatching to indicate what's new, what's different.
Woody, on that second one, sorry, I was busy fervently writing notes on the first one. The second, can you explain the second one again?
Yeah, no, I'd like to see the 2019 plans, and much as we do, Jeff, whenever we deal with issues of massing and other kinds of changes, I'd like to see the plans again with full dimensions on all the elevations and setbacks, but also some sort of shading, cross-hatching, some indication of what's different from the prior plan. And I'd like to see that done for the 2020 as-built. What's different from the 2019 plan that Bob approved? I think it'd be very helpful. John had some with his red pen and all, you could pretty that up a little bit, but.
Woody?
Yeah.
I'm not sure they're on the 2020. We could probably ask for as-built foundations, but I don't know whether construction has gotten to the point where we could have as-built.
It's framed.
Is it fully framed? Okay.
I don't know, isn't it? I mean.
Yeah, I think you could.
But you come pretty close. It looks fully framed to me. I may be wrong, but close enough. The other thing I would say, obviously, because of the issues in front of us, it's far from clear where we're coming out. I don't want to recommend. I don't want to tell Mr. Stasko what he should do, but I would perhaps keep my powder dry for the moment in terms of further construction until we can hopefully bring this to some sort of acceptable resolution. I mean, it's not, it's caveat emptor, but you and Mr. Jeff, you and your client can decide how much further to go before we have our next hearing.
Yeah, I'll have a discussion with him. Yep.
Yeah, I mean, that's. Other comments from the boards. I just chimed in with what I'd like to see, which are the sort of three sets of plans with changes and dimensions, elevations, etc. Is there more information you'd like to see? Is there any sort of cases we've had or case law you'd like to reference?
Who, me?
Anybody? No. I'm thinking of the board. But no. We have the opportunity. I mean, I'm sure both sides will be presenting again a summary or rebuttal or whatever. But to be fair to you guys, so we don't play gotcha. Are there things that we'd like to see from either of you at our next hearing that haven't been mentioned? All right.
I guess the one thing that I'm interested in is on the 8.9 issue. how can we be assured that the building that's going up now is the same footprint and vertical building that was there before if we don't have a plan for the building that was there before?
Well, there was, good question. There was a full elevation, was there not, or elevations at our 2017 hearing, even though the dimensions weren't cited? Or am
I think I have.
imagining?
I think I have that plan. Let me see if I can share my screen, if I can find it.
Yeah, and it was easier to see in your screen than the,
And I just, this is
of a
literally,
site plan, but
hold on. Okay, now, is there any, this is the first time I'm doing this, so.
So I made you a co-host, so you should be able, there's a green arrow on the bottom, and then you will have to probably have saved it into a file for you to share it.
Okay, great. I think I have it here. So can you see my screen right now?
yeah.
All right. So this plan is dated February 4th, 2019. So it's the building permit plan. Let's see if I can get it close up here. And you can see the chart indicating that the interpretation, at least by Merrill at the time in preparation of this plan, was that there was no rear yard requirement. See if I can zoom in and if this answers your questions. Is that the type of information? I'm happy to provide that on paper to you.
Okay, and Jeff, I'm also looking at Axons Drawings at our 2017 hearing, numbers A3, A4, A5, in addition to the vertical. A3, 4, and 5 all show the elevations. They weren't always, it didn't have all the dimensions, but I'm pretty sure they can be easily reconstructed.
Yeah, I have them. I have them here on my hard drive. So
It's just really adding the notations or the measurements. It's not.
Yeah.
Doesn't require new drawings.
Yeah. So we'll look into that, Woody. I'm not
Okay.
prepared to upload it at the moment.
That'd help.
Yep.
Okay. Other information the board would like to request of.
But let me just ask David. David, you indicated how can we be assured, that the building going up is the same footprint and vertical plan as what was previously there. Does this plan help to answer that question for you?
It might.
I also have this.
It doesn't help at all with the vertical.
Yeah.
No, but those are the others, Dave. The A3, 4, and 5. It was in our packet, but there are an awful lot of pieces of paper.
Yeah. Okay.
See if I can hone in on that for you guys.
I think you've got the guts of what we want.
Yeah.
If you.
And we just have to do the comparison.
Right.
Essentially.
And then do the 2020 as built, anything that's different.
Ask for the opportunity to review those materials before our hearing.
They're a matter of public record, but as far as any new materials that I submit to the board, I'll make sure I get them to you a week in advance of the hearing.
Yeah, that's been our practice. As Jeff knows, all material should come into us. It's public, but it all should come into us a week in advance.
Does the board desire to see, well, I have it right here. So this is the email that was sent over to Bob, which was the stamped as-built foundation plan. And if I scroll down, I'm sure that this is probably in your packet as well. But this is
Looks familiar, but I don't know. I mean, there's.
Yeah, so just to let you know, it's in the building department's file, an as-built foundation plan that was generated this year, which attempts to show the foundation of the existing house where we're reconstructing the new home.
So I can't find it right now, so it may not be in my packet, but it's easily cross-hatched or in some fashion.
Yeah, I'll send it to you.
Yeah.
I think I know what you want. Okay.
Okay. Anybody else? You know, about 3 or 4 months ago, I mentioned to Jen that life had gotten very quiet with the zoning board. Nothing was interesting was coming before us, so on and so forth.
What this means
Shame
is
on
that
me.
this is Woody's
Shame
fault.
on me.
Is what we're saying.
So is this, when we continue this, is it going to be continued to our next meeting?
Is it going to be on October 6th, Jen, or are we going to continue it beyond?
So I think we're going to need more time. I would think you're going to need more time until October 6th. I was going to suggest the November hearing only because our October 6th meeting is already set.
Yeah.
I know that to do all these plans, plus make sure that they're filtered to all the appropriate parties. And
it gets to us a week in advance, which
Right,
is the end of
right.
September, and
So I have on the agenda, I know we have to do all the closings and continuings and all that, but to get a letter for each appeal to extend it to.
yeah, I think haste would make waste here. I'd
Right.
rather, with all apologies to either or both sides, I'd rather take the time and be diligent about it.
Right.
And
Make
so
sure
I would move that we continue this until November
10th.
10th.
If we opened all 3 appeals?
No,
No,
so this is the
I'm
first
sorry.
one.
Just the
Okay, we
first
can
one.
continue this hearing, but we'll maybe vote.
Before you open the other 2 hearings, I just kind of wanted to point out what I think is the obvious and just kind of make a plea to you all. And that is I don't want to diminish the fact that there's been construction activities that have commenced that are fairly definite construction activities, meaning foundation and walls and so forth, that were allowed to proceed. And I just wanted to make the obvious point that I think that the applicant's entitled, to rely upon the interpretations of the building inspector. And it would be a shame if there's an argument, for instance, on how to interpret the zoning bylaw with respect to side yard and rear yard setbacks, and maybe a counter equally as reasonable interpretation for the board. And I just wanted to make the point that the plea that, recognizing the reality of the situation that we're in, that the board, understand that, we're working on, a zoning decision, building permit issuances, interpretations that are made during the course of this project. And, we should be, entitled to rely on it. So,
Well, in a way, Jeff, yes, I would agree in principle, but in 2 instances, lot coverage and the measurement of height, I do rely on precedent there. I would argue that there are probably 30 to 50 cases that have taken the universal definition of 10 feet around the perimeter of an entire structure, and probably 30 to 50 cases that have dealt with the pervious nature of a unroofed deck versus a roofed deck. Those are classic cases we've had. So it isn't that this was arbitrary. This is the practice and precedent this board's followed for 20 or 30 years. And I can't think of an exception.
May I add a comment to that, which is that the permission that Mr. Stasko sought from Bob Egan was based on plans that didn't accurately represent what he intended to build. And now he's made a changed circumstance, which is of his own making, and has put all of us in the position of having to reckon with it. And I have a great concern here allowing construction to continue until November 10, knowing that Stasco, when he got notice of our appeals and our challenging of his construction, he apparently has rapidly accelerated construction. He wants to try to finish this project and let the cat out of the bag so that it can't be unwound.
Are you afraid, Attorney Curtin, that this board would be swayed by that and, vote against, decide against a rational decision or a better judgment?
No, I don't suspect that of this board, but it's a fear I have, not of you, just internally, that it would be hard to undo. It would be harder to undo a finished construction compared to halting construction now and more easily allow Mr. Stasco to make changes that would be compliant with the bylaw and this board's ultimate ruling.
Well, okay, let me ask Attorney Amara, Town Council, are we within our rights to impose what amounts to a cease and desist at this point until we render a decision? Or is that strictly up to to Mr. Stasco?
It's without looking at a little more detail. Generally, he has received permits and he's entitled to rely on them. Now, if he wants to act on those permits, he can do so at his peril if the board then decides that the decision should be overturned or not. Generally, depending on the situation, my gut on this is that there are certain parts of this construction that are not really at issue here, that would not be impacted. I understand the arguments being raised by both sides, but I do believe he has the requisite permits to proceed if he so chooses at this point.
If he so chooses.
That's a decision for him to make with his attorney, in my mind.
That's what I was trying to signal to Mr. DeLisi. I mean, I think he should have that discussion with Mr. Stasco.
Yeah, and I indicated I'll have that discussion just to kind of amplify one of the reasons why one of the main reasons why the construction has continued at the pace it has is because Mr. Stasco and his wife are expecting a baby and they'd like to move back into their house at the outset of this project. They didn't expect that they would have to tear the entire house down. It obviously posed its challenges. I'm also going to point to the 2019 plan that I put up a few minutes ago. When the board receives it during this period of time between hearings, I just thought that I would point to the building coverage calculations that are on there. I haven't had an opportunity to think about them, but they're there in the chart that I provided.
Okay, I mean, there's a lot to digest.
Yeah.
So Attorney Curtin, I mean, I think that's, as I said earlier, caveat emptor. We'll decide based on the merits as we see them, and whether the house is entirely built or not a single nail, is pounded in further is irrelevant. I really could care less. I think we have to call it the way we see it.
As a practical matter, there's just small portions of this project that are in question. Assuming that it's an 8.9, actual vertical footprint.
The envelope, yeah.
And, we don't have a problem with that part.
No, that's right. Yeah, some of these don't. I mean, I agree. The 8.9 that didn't require approval in the first place.
Just to give you an example, is at some point in the month, the mid, I think it was the 17th, I was on vacation. I received a letter from Bob indicating that, the bump out is in question. You're not permitted, because my determination is you can't proceed with that until you get a new building permit. And we responded to him and we indicated we understand that we had no intention of building the bump out at this time. So the project, to David's kind of point, is there are many aspects of the project that need to go forward that are not in dispute. So, but I will have the discussion with Ryan and his wife, and we'll consider these issues.
All right. I think it's only fair. So, Jim, we should open up the second and third appeals and then continue them?
Yeah, so we should do that after you continue this first one.
Okay.
We didn't finish the vote.
I'd like to make a motion to continue this until November 10th, this hearing. This
Second.
appeal. All right, moved and seconded. Do you want again, a voice recognition, Jen, on this?
Yes, please, a roll call vote. Thank you.
Roll call. All in favor, Woody Chidick, aye. Well, go ahead.
Dave McMorris, aye.
Okay.
Matt Watkins.
Peter Gertica, aye.
Okay, Matt's ayed.
And Peter,
And Lee. Okay, so we got that. Now, I'd like to open the second hearing on an appeal by attorney Jeffrey DeLisi on behalf of his client Ryan Stasko, who's appealing the building inspector's letter of July 1st, 2020. They would like the ZBA to confirm the issuance of the building permit that Bob had issued. I would make a motion to continue this hearing until November 10th.
Second.
Okay, so McMorris, Chidick, aye. Lee Darst, Matt?
Matt Watkins, aye.
Okay,
Peter Gertica, aye.
Dave McMorris, aye.
okay, I thought I'd gotten you guys, but, and the third is an appeal by Jill Mikesell, I guess, and Jason Curtin on behalf of the Wyndhams to appeal the building inspector's failure to issue an enforcement order requested by the Wyndhams. It's really a cease and desist order they had requested, and the building inspector has refused to enforce that. I would make a motion to continue that hearing until November 10th.
Second.
Okay, moved and seconded by Matt Watkins. Woody Chidick, aye.
Dave McMorris, aye.
Peter Gertica, aye.
Lee Darst, aye.
Matt Watkins, aye.
Okay, we got 5.
and I would just like to request an extension letter from both Attorney Curtin and Attorney DeLisi.
Oh, yeah.
Allowing all 3 to be continued until the end of December. We won't do that, but we need to have time, and that would be the continuance of the appeals.
The appeal period is 100 days, and you're saying we're
so
going to run into it.
We're going to run out of that, and we want to have an extension that will give us not only to get past 100 days, but allow for a filing of the decision. So I think it would be safe if we hear an 11/10, and then you want to do it, if you want to file a decision in 2 weeks, you could do that. But it might be safer to ask for say December 30th.
Okay.
Will do. Okay.
Also, Jen, I think there's a couple of questions.
Oh, let me just.
Who?
Yes, there's just a couple. We can probably answer. So one, they didn't. We also need people's addresses if they do. I can look this up. But Miss Beth McGillivray, is it appropriate to ask if anyone on the committee, meaning the board, has a personal or a business relationship with either the Staskos or the Wyndhams? If so, should that be identified?
Sure. And I do not, or I would have recused myself. Does anybody on the board, you don't have to answer individually, but does anybody on the board have a relationship with either of these 2 parties that might
They're asking if there's a conflict.
affect your decision making?
None.
People are shaking their heads no.
Okay. And then the other one is from a Courtney Murphy. Also, we don't have their address, so I can just write it down. But how will the neighbors be notified of changes to plans? And that question is they won't be. We only notice we are continuing this to November 10th, but anyone can email me, joram@cohassetma.org, and I can certainly, if I have anything, send them if I have them.
Yeah, not clear what that person might have meant by plans.
I'm guessing the new plans for when these are updated by Mr. Stasko.
Okay. Oh, you mean sort of identified? Yeah.
Right.
Well,
So they'll have to reach out to us, and then if we have them, we will send them.
Okay, and Attorney Curtin, would you also agree to an extension of the appeal period?
I agree with my mentioning that we do have deep concerns about allowing this project to continue to be constructed for the amount of time that you're asking for a continuance. So I would ask that Attorney DeLisi have a serious conversation with Mr. Stasco about refraining from construction of any of the disputed aspects of the structure.
Okay, well, you're going to have to take me at my word. I can't really speak for the full board, but we're going to decide this on its merits, regardless of money invested. But I hear you. But I think it would be a disservice to everybody if we rush to judgment prematurely. There are some complexities here, as you know. If we could dispense with this in November, fantastic. I suspect we may not because of the complexities. We haven't deliberated. We haven't even seen all the evidence yet.
Understood. I just wanted to reiterate that point.
Yeah, okay.
And the thing is that we will need that letter in writing, and we should check on that on October 6th, because if we're getting tight on time, we don't have extensions, and we'll need to schedule another hearing.
You mean a special hearing?
A special hearing if we don't have it, so that we can make the timelines.
Is the board in this era of COVID, without having a date certain in mind, flexible if we need to have an interim hearing as opposed to meet till midnight on, some date?
So to be clear, we're planning on taking this up at our normal November, 10th meeting?
The 10th, yeah.
Okay.
And if it looks as though the agenda and the calendar is getting really clogged, we may have to do what we've done tonight, which is to have a special interim meeting just to deal with this one issue, which would, I think, be to everybody's benefit, would be moving the ball forward. But let's I don't want to make that decision tonight.
Okay.
Okay, so any other business to be conducted?
No.
Would you like a motion to adjourn?
I would, unless,
So moved.
okay. It's moved. Anybody second?
Second.
Dave McMorris second. Woody Chidick, aye.
Lee Darst, aye.
David Morris, aye.
Matt Watkinson.
Okay, so all five of us have agreed to continue the hearing, to close the hearing until,
The meeting. Continue the hearing, closing the meeting.
yeah, close the meeting.
All right. Thank you all. Have a great night.
Okay,
Good night.
good night.